So what exactly counts as a mass layoff in Switzerland? Let's break down the rules.
We all know layoffs are tough. They affect real people, which is why Swiss law is so specific.
But for the law, it's not about feelings. It all starts with the numbers.
This is what the law calls a Massenanlassung, and the definition is super precise.
It all comes down to these thresholds, which are based on the size of the business unit.
Okay, so who actually gets included in these counts? It's not as simple as you'd think.
Pretty much everyone gets counted. Full-time, part-time, even interns and apprentices.
And this is the most important part. The law separates the company from the establishment.
The rules apply to each branch or factory separately, not the whole company combined.
A case with Swiss Post really makes this clear. An employee made a pretty interesting argument.
But the court said no. Each post office is its own Betrieb. That's a huge deal.
So if the numbers hit that threshold, what happens next? A whole mandatory process kicks in.
And these 3 steps, inform, consult, and notify, are absolutely required, no skipping them.
Good faith means they actually have to listen to employee ideas, even if they say no.
And get this, nothing is final for 30 days after the labor office is told.
But what if a company messes this up? Well, the penalties are pretty severe.
If they don't consult properly, every single dismissal is abusive. That means big compensation payouts.
And sometimes there's another even bigger step, negotiating a social plan. This kicks in only for larger establishments. We're talking over 250 employees. And if they're laying off at least 30 people from that group. These plans are all about softening the blow with real, practical help for those affected.
So there's a strict legal process, for sure, but does it really cushion the fall? That's the big question.